Question 1. Research into the regulatory framework governing the reporting of suspicious financial activities within Astra International's operating jurisdiction reveals a client engaging in a series of complex, high-value transactions that appear to lack clear economic or lawful purpose. The client's business activities are opaque, and the transaction patterns are unusual for their stated industry. Junior analyst flags these transactions as potentially indicative of money laundering. What is the most appropriate professional course of action for the analyst to take? Option A. Immediately escalate the findings to the firm's compliance department for further investigation and potential reporting to the relevant financial intelligence unit. Option B. Advise the client to restructure their transactions to appear more legitimate before proceeding. Option C. Conduct an independent, external investigation into the client's background without informing the firm's compliance department. Option D. Disregard the flagged transaction, as they are not definitively proven to be illicit and could be a misunderstanding of the client's business. The correct answer is A. Immediately escalate the findings to the firm's compliance department for further investigation and potential reporting to the relevant financial intelligence unit. Explanation. This scenario presents a professional challenge due to the inherent conflict between client confidentiality and the regulatory obligation to report suspicious activities. Professionals must navigate this delicate balance, ensuring they uphold their fiduciary duties to the client while also adhering to anti-money laundering (AML) and counter-terrorist financing (CTF) regulations. The Astra International Hiring Assessment Test likely assesses the candidate's understanding of these critical compliance areas. The correct approach represents best professional practice because it prioritizes a thorough internal investigation and escalation process, aligning with regulatory frameworks that mandate reporting of suspicious transactions (SDR) to the relevant authorities. This process allows for the collection of sufficient information to form a reasonable suspicion, thereby avoiding premature or unfounded reporting, which could harm the client and waste regulatory resources. It also demonstrates adherence to internal compliance policies and procedures, which are designed to meet regulatory expectations. An incorrect approach that involves ignoring the red flags or failing to report them would constitute a direct breach of AML/CTF regulations, potentially leading to severe penalties for both the individual and the firm. This failure to act demonstrates a lack of due diligence and a disregard for the firm's compliance obligations. Another incorrect approach, such as immediately reporting without any internal investigation, could be seen as a breach of client confidentiality without sufficient grounds, potentially damaging client relationships and the firm's reputation, and may not meet the threshold of reasonable suspicion required by regulators. Professionals should employ a structured decision-making framework when encountering suspicious activity. This framework typically involves 1. Identifying and documenting all red flags. 2. Conducting a preliminary internal review to gather more information and assess the context. 3. Consulting with internal compliance or legal departments. 4. If suspicion remains, preparing and submitting a suspicious activity report, SAR, or equivalent to the relevant regulatory body. This systematic approach ensures that actions are taken based on a well-founded suspicion, balancing regulatory requirements with professional responsibilities. Question 2. Benchmark analysis indicates that a client who has expressed a strong preference for a particular high-risk speculative investment product based on recent market hype is seeking advice. The financial advisor has reviewed the client's profile and believes this product is unsuitable due to its volatility and the client's moderate risk tolerance. What is the most appropriate course of action for the financial advisor? Option A. Recommend a different investment product that offers a higher commission to the advisor, as this would compensate for the time spent on a potentially difficult client. Option B. Explain to the client why the preferred investment is unsuitable, detailing the risks and potential negative outcomes relative to their stated objectives and risk tolerance, and then propose alternative investments that align better with their profile. Option C. Proceed with the client's preferred investment, as their instructions are paramount, and document their explicit consent to proceed against the advisor's recommendation. Option D. Politely decline to advise the client on this specific product, suggesting they seek advice from a specialist who may be more aligned with their investment preferences. The correct answer is B. Explain to the client why the preferred investment is unsuitable, detailing the risks and potential negative outcomes relative to their stated objectives and risk tolerance, and then propose alternative investments that align better with their profile. Explanation. This scenario presents a professional challenge due to the inherent conflict between client instructions and regulatory obligations. The financial advisor must navigate the client's desire for a specific investment strategy with the paramount duty to act in the client's best interest and adhere to the principles of suitability and responsible investment, as mandated by the Astra International Hiring Assessment Tests regulatory framework. The advisor's judgment is critical in balancing client autonomy with their fiduciary responsibilities. The correct approach represents best professional practice because it prioritizes a thorough understanding of the client's financial situation, risk tolerance, and investment objectives before recommending any product or strategy. This aligns directly with the regulatory requirement to ensure that all investment recommendations are suitable for the client. Furthermore, it demonstrates a commitment to transparency by clearly explaining the risks and potential downsides of the proposed investment, empowering the client to make an informed decision. This proactive approach mitigates potential future disputes and upholds the advisor's ethical duty of care. An incorrect approach that involves proceeding with the client's preferred investment without adequate due diligence fails to meet the suitability requirements. This could lead to the client investing in products that are too risky, illiquid, or otherwise inappropriate for their circumstances, potentially resulting in significant financial losses. Such an action would be a direct violation of regulatory guidelines designed to protect investors. Another incorrect approach, which involves dismissing the client's concerns and proceeding with a different, albeit potentially suitable, investment without proper discussion, demonstrates a lack of client centricity and poor communication. While the investment itself might be appropriate, the failure to address the client's initial request and explain the rationale for an alternative recommendation erodes trust and can be seen as a breach of the duty to act with integrity and in good faith. A further incorrect approach, which involves recommending a product solely because it offers higher commission, is a clear ethical and regulatory failure. This prioritizes the advisor's personal gain over the client's best interests, constituting a conflict of interest and a breach of fiduciary duty. Regulatory frameworks strictly prohibit such self-serving recommendations. The professional decision-making process for similar situations should involve a structured approach. 1. Understand the client. Thoroughly assess the client's financial situation, investment objectives, risk tolerance, and any specific constraints or preferences. 2. Assess suitability. Evaluate whether any proposed investment or strategy aligns with the client's profile and regulatory suitability standards. 3. Discuss and explain. Clearly communicate the rationale behind any recommendation, including potential benefits, risks, costs, and alternatives. Address client concerns directly and transparently. 4. Document decisions. Maintain detailed records of all client interactions, assessments, recommendations, and client decisions. 5. Adhere to regulations. Ensure all actions and recommendations comply with the applicable regulatory framework, ethical codes, and internal policies. 6. Seek clarification/escalate. If there is any ambiguity or conflict between client wishes and regulatory requirements, seek guidance from compliance or senior management. Question 3. Risk assessment procedures indicate that a client's stated risk tolerance, as documented in their initial onboarding questionnaire, appears to be significantly higher than their actual investment behavior during periods of market volatility suggests. The client has a history of making impulsive decisions to sell assets during downturns, despite expressing a desire for aggressive growth. Which of the following represents the most appropriate professional approach to address this discrepancy? Option A. Continue to adhere strictly to the client's initial risk tolerance questionnaire, assuming their stated preferences are the definitive guide for investment strategy, and explain to the client that market fluctuations are normal. Option B. Initiate a detailed discussion with the client to explore the reasons behind their reactive selling behavior during market downturns and reassess their true risk capacity and willingness to take risk, adjusting the investment strategy accordingly to align with their demonstrated behavior and long-term suitability. Option C. Immediately adjust the investment strategy to a significantly more conservative allocation to match the client's selling behavior without further discussion to prevent future reactive decisions. Option D. Focus solely on the client's stated desire for high returns and recommend investment products that offer the potential for aggressive growth, regardless of their demonstrated risk aversion during volatile periods. Correct answer is B. Initiate a detailed discussion with the client to explore the reasons behind their reactive selling behavior during market downturns and reassess their true risk capacity and willingness to take risk, adjusting the investment strategy accordingly to align with their demonstrated behavior and long-term suitability. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent conflict between a client's stated risk tolerance and their actual investment behavior, which often deviates from their stated preferences. The firm's obligation is to act in the client's best interest, which requires a nuanced understanding beyond a simple questionnaire. The challenge lies in reconciling the client's expressed desires with their demonstrated actions and the potential for emotional decision-making during market volatility. This necessitates a proactive and analytical approach to ensure the investment strategy remains aligned with the client's true capacity and willingness to take risk, rather than solely relying on initial declarations. Correct approach analysis. The correct approach represents best professional practice because it prioritizes a holistic and ongoing assessment of the client's risk profile. It acknowledges that stated risk tolerance can be aspirational or influenced by current market sentiment, and that actual behavior during stressful market conditions is a more reliable indicator of true risk appetite. This aligns with the regulatory framework's emphasis on suitability and client best interests, requiring financial professionals to understand the client's circumstances, objectives, and risk tolerance comprehensively. By reviewing past investment decisions and client reactions to market movements, the professional can identify discrepancies and proactively adjust the strategy to prevent potential harm or misalignment. This demonstrates a commitment to fiduciary duty and robust client relationship management. Incorrect approaches analysis. One incorrect approach fails by solely relying on the initial risk tolerance questionnaire. This is a regulatory and ethical failure because it treats a static document as a definitive and unchanging measure of risk. It ignores the dynamic nature of client circumstances, market conditions, and the psychological impact of investment performance on decision-making. This approach can lead to unsuitable recommendations if the client's actual risk-taking capacity has changed or was never accurately captured by the questionnaire. Another incorrect approach is to prioritize the client's immediate emotional reactions during market downturns over a long-term, suitability-based strategy. This is an ethical failure as it can lead to reactive, short-sighted decisions that are detrimental to the client's financial goals. While empathy is important, financial advice must be grounded in objective analysis and a well-defined investment plan, not solely on appeasing immediate anxieties, which can result in selling low and buying high, contrary to sound investment principles and regulatory expectations for prudent advice. A third incorrect approach involves assuming that a client's stated desire for high returns automatically equates to a high risk tolerance. This is a regulatory and ethical failure because it conflates a financial objective with the capacity and willingness to bear the associated risks. High returns typically come with higher volatility and the potential for significant losses, which a client may not be psychologically or financially equipped to handle, even if they express a desire for such returns. This approach can lead to recommendations that are unsuitable and expose the client to unacceptable levels of risk. Professional reasoning. Professionals should adopt a decision-making process that begins with understanding the client's stated objectives and risk tolerance as a starting point. However, this must be followed by a deeper investigation into their financial situation, investment experience, and behavioral patterns. Regular reviews, including discussions about past investment decisions and reactions to market events, are crucial. When discrepancies arise between stated preferences and observed behavior, professionals must engage in open dialogue with the client to clarify their true risk profile and adjust the investment strategy accordingly, always prioritizing the client's best interests and regulatory compliance. Question 4. Which approach would be most appropriate for a financial advisor who, while processing a large, unusual cash deposit for a client, observes a detail that raises a potential concern regarding money laundering activities, but lacks definitive proof? Option A. Discreetly conduct further internal due diligence and gather additional, non-intrusive information to assess the validity of the concern before escalating. Option B. Immediately file a suspicious activity report (SAR) with the relevant authorities based on the initial observation. Option C. Directly question the client about the specific detail that raised the concern, revealing the advisor's suspicion. Option D. Proceed with the transaction as normal and disregard the observation, assuming it is a misunderstanding. The correct answer is A. Discreetly conduct further internal due diligence and gather additional, non-intrusive information to assess the validity of the concern before escalating. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent conflict between client confidentiality and the regulatory obligation to report suspicious activities. The financial advisor must navigate the delicate balance of maintaining client trust while adhering to anti-money laundering (AML) regulations. Failure to report could have severe legal and reputational consequences for both the advisor and the firm, while an unfounded report could damage the client relationship and lead to unnecessary scrutiny. Correct approach analysis. The correct approach involves discreetly gathering further information to corroborate or refute the initial suspicion without alerting the client. This aligns with the principles of responsible financial advice and regulatory compliance. Specifically, it adheres to the spirit of AML regulations, which require a reasonable suspicion to be reported, but also implicitly encourage due diligence before making such a report. This approach allows for more informed decision, minimizing the risk of both a missed report and a false alarm. It upholds the professional duty to act in the client's best interest while fulfilling statutory obligations. Incorrect approaches analysis. One incorrect approach involves immediately reporting the suspicion to the relevant authorities without further investigation. This fails to meet the standard of reasonable suspicion, which typically requires more than a single, uncorroborated observation. It could lead to an unnecessary investigation, damage the client relationship, and waste regulatory resources. Ethically, it breaches the duty of care to the client by acting prematurely on suspicion. Another incorrect approach is to ignore the suspicion and continue with the transaction. This is a direct violation of AML regulations, which mandate reporting of suspicious activities. It exposes the advisor and the firm to significant legal penalties, reputational damage, and could facilitate criminal activity. Ethically, it represents a dereliction of professional duty and a failure to uphold market integrity. A further incorrect approach is to subtly question the client about the source of funds in a way that directly reveals the suspicion. This breaches client confidentiality and could alert the client to the investigation, potentially leading to the destruction of evidence or further obfuscation. It is unprofessional and counterproductive to the investigative process. Professional reasoning. Professionals facing such a situation should employ a structured decision-making process. First, identify the potential regulatory or ethical breach. Second, assess the available information and its reliability. Third, consider the least intrusive yet effective means of gathering further information to confirm or dismiss the suspicion. Fourth, consult with internal compliance officers or legal counsel if uncertainty persists. Finally, act decisively based on a well-reasoned assessment, ensuring all actions are documented. Question 5. The review process indicates that a client who has expressed a desire for capital preservation and low volatility is now insisting on investing a significant portion of their portfolio in a highly speculative emerging market technology stock. You have concerns that this investment does not align with their stated objectives and carries substantial risk. What is the most appropriate course of action? Option A. Engage in a detailed discussion with the client, clearly outlining the risks and potential downsides of the speculative stock in relation to their capital preservation and low volatility objectives, explaining alternative suitable investments, and documenting the conversation and the client's final decision. Option B. Refuse to execute the trade, informing the client that you will only proceed with investments that align with their stated objectives, and suggest they seek advice elsewhere if they disagree. Option C. Proceed with the client's requested investment, documenting their insistence, but without further detailed discussion of the risks to avoid upsetting them. Option D. Execute the trade as requested, but include a disclaimer in the confirmation statement that the investment is speculative and may not be suitable for their stated objectives. The correct answer is C. Proceed with the client's requested investment, documenting their insistence, but without further detailed discussion of the risks to avoid upsetting them. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent conflict between a client's stated wishes and the advisor's fiduciary duty to act in the client's best interest, particularly when those wishes might lead to suboptimal outcomes or increased risk. The advisor must navigate this delicate balance, ensuring compliance with regulatory requirements for suitability and client understanding, while respecting client autonomy. The challenge lies in providing clear, objective advice without being overly prescriptive or dismissive of the client's preferences, which could damage the professional relationship. Correct approach analysis. The correct approach involves a thorough and documented discussion with the client, clearly outlining the risks and potential downsides of their preferred investment strategy, while also explaining the benefits of alternative, more suitable options. This aligns with the regulatory framework's emphasis on suitability, client disclosure, and the advisor's duty to ensure the client understands the implications of their investment decisions. By providing comprehensive information and seeking confirmation of understanding, the advisor upholds their fiduciary responsibility and ensures the client's decision is informed, even if it deviates from the advisor's initial recommendation. This process also serves as crucial documentation for regulatory compliance. Incorrect approaches analysis. One incorrect approach involves proceeding with the client's preferred investment without further discussion or documentation. This fails to meet the regulatory requirement for suitability assessment and adequate client disclosure. The advisor is not acting in the client's best interest if they know the chosen investment carries undue risk or is unlikely to meet the client's stated objectives, and they have not taken steps to inform the client of these concerns. This could be viewed as a breach of fiduciary duty and a violation of conduct rules. Another incorrect approach is to dismiss the client's wishes outright and insist on a different investment without a detailed explanation of the rationale or exploring the client's underlying motivations. This demonstrates a lack of client centricity and can be perceived as patronizing, potentially damaging the client relationship and failing to address any valid, albeit perhaps misguided, reasons behind the client's preference. Ethically, it fails to respect client autonomy. A third incorrect approach is to proceed with the client's preferred investment while downplaying the associated risks to avoid upsetting the client. This is a clear violation of disclosure obligations. Regulators expect advisors to be transparent about all material risks, even if it makes the client uncomfortable. Failing to do so is a serious ethical and regulatory breach, as it misleads the client and prevents them from making a truly informed decision. Professional reasoning. Professionals should employ a structured decision-making process that prioritizes client understanding and regulatory compliance. This involves 1. Identifying the conflict. Recognize when a client's request may not align with their best interests or regulatory suitability standards. 2. Information gathering. Understand the client's rationale behind their request. 3. Disclosure and education. Clearly explain the risks, benefits, and implications of both the client's preferred option and recommended alternatives, using plain language. 4. Documentation. Meticulously record all discussion, advice given, client acknowledgments, and the final decision. 5. Seeking confirmation. Ensure the client understands the information provided and confirms their decision. If the client remains insistent on a suboptimal choice after thorough discussion, the advisor must document this extensively and consider whether continuing the professional relationship is appropriate if it compromises their ability to act ethically and in accordance with regulations. Question 6. The analysis reveals that a client, Mr. Henderson, has approached a financial advisor expressing a strong desire to invest in a new, high-yield cryptocurrency-backed fund that promises significant short-term gains. Mr. Henderson states he is willing to accept a high level of risk to achieve these returns, and has indicated he has a substantial amount of capital he is prepared to allocate. The advisor has a basic understanding of the fund's mechanics, but has not conducted a detailed assessment of Mr. Henderson's overall financial situation, his experience with volatile assets, or his specific investment goals beyond the stated desire for rapid growth. What is the most appropriate course of action for the financial advisor in this situation, adhering to the principles of professional conduct and regulatory compliance? Option A. Investigate the fund's historical performance data and present this to Mr. Henderson, highlighting the potential for high returns, and then allow him to make the final decision. Option B. Conduct a comprehensive fact-find to assess Mr. Henderson's full financial circumstances, investment objectives, risk tolerance, and understanding of the product's complexities and risks before making any recommendation. Option C. Decline to recommend the fund and advise the client to seek advice from a specialist in cryptocurrency investments, as the advisor lacks sufficient expertise in this specific asset class. Option D. Proceed with recommending the cryptocurrency-backed fund, as the client has explicitly stated his risk tolerance and desire for high returns, and the advisor should respect the client's wishes. The correct answer is D. Proceed with recommending the cryptocurrency-backed fund, as the client has explicitly stated his risk tolerance and desire for high returns, and the advisor should respect the client's wishes. Explanation. The analysis reveals a scenario where a financial advisor, operating within the Astra International Hiring Assessment Test's regulatory framework, assumed to be UK/SISI for this example, as no other jurisdiction is specified, is presented with a client seeking advice on a complex investment product. The professional challenge lies in balancing the client's stated desire for high returns with the advisor's fiduciary duty to ensure the investment is suitable, understood, and aligned with the client's risk tolerance and financial objectives. This requires a deep understanding of client needs assessment, product knowledge, and regulatory obligations concerning client suitability and disclosure. The correct approach prioritizes a thorough, documented assessment of the client's financial situation, investment objectives, risk tolerance, and knowledge of financial products. This aligns with the SISI Code of Conduct and relevant FCA, Financial Conduct Authority, regulations, which mandate that financial advice must be suitable for the client. Documenting this assessment is crucial for demonstrating compliance and protecting both the client and the advisor. It ensures that any subsequent recommendation is justifiable and based on a comprehensive understanding of the client's circumstances, thereby upholding the principles of acting with integrity and in the client's best interests. An incorrect approach that focuses solely on the client's stated desire for high returns without a comprehensive suitability assessment would be a significant regulatory and ethical failure. This would violate the principle of acting in the client's best interests and could lead to the client investing in a product that is too risky or inappropriate for their circumstances, potentially resulting in substantial financial loss. Such an approach would also likely breach FCA rules on treating customers fairly and providing suitable advice. Another incorrect approach that involves recommending a complex product without ensuring the client fully understands its risks, charges, and potential outcomes is also professionally unacceptable. This demonstrates a failure in the duty of care and transparency, potentially misleading the client and exposing them to unforeseen risks. This would contravene regulatory requirements for clear and fair communication and adequate disclosure of product features and associated risks. The professional decision-making process for similar situations should involve a structured approach. 1. Understand the client. Conduct a detailed fact-find to gather comprehensive information about the client's financial situation, objectives, risk appetite, and investment horizon. 2. Assess suitability. Evaluate whether the proposed investment product aligns with the client's profile and objectives, considering all associated risks and benefits. 3. Ensure understanding. Clearly explain the product's features, risks, charges, and potential outcomes in plain language, ensuring the client comprehends them. 4. Document everything. Maintain thorough records of all client interactions, assessments, recommendations, and client decisions. 5. Act in best interests. At all stages, prioritize the client's welfare and ensure all actions are taken with their best interests at heart, adhering to regulatory and ethical standards. Question 7. The evaluation methodology shows a financial advisor has been offered a substantial personal bonus by a fund management company if they successfully persuade their clients to invest in that company's new fund. The advisor believes the fund has merit, but is also aware of the significant personal financial benefit the bonus represents. Under the Astra International Hiring Assessment Test's assumed regulatory framework, UK/SISI, which of the following actions best demonstrates adherence to professional and ethical obligations? Option A. Fully disclose the bonus offer to the client and the firm, explain the potential benefits and risks of the fund, and proceed with the recommendation only if the client, fully informed of the incentive, agrees and the fund is demonstrably suitable. Option B. Decline the bonus but proceed with recommending the fund to clients, as the advisor believes it is a good investment without mentioning the bonus offer to anyone. Option C. Accept the bonus and recommend the fund to clients, assuming the fund is a suitable investment and the bonus is a private arrangement. Option D. Recommend the fund to clients only if it is the absolute best investment available, and then accept the bonus without disclosing it to the client or firm. The correct answer is A. Fully disclose the bonus offer to the client and the firm, explain the potential benefits and risks of the fund, and proceed with the recommendation only if the client, fully informed of the incentive, agrees and the fund is demonstrably suitable. Explanation. The evaluation methodology shows a scenario where a financial advisor, operating under the Astra International Hiring Assessment Tests regulatory framework, assumed to be UK/SISI for this example, as no specific jurisdiction was provided beyond the exam name, and SISI is a common UK-based professional body, faces a conflict of interest. The advisor has been offered a significant personal incentive by a fund manager to recommend their products to clients. This situation is professionally challenging because it directly pits the advisor's personal financial gain against their fiduciary duty to act in the best interests of their clients. The core of the challenge lies in maintaining objectivity and integrity when personal incentives are present. The correct approach represents best professional practice because it prioritizes client interests above all else, adhering strictly to the principles of professional conduct and regulatory requirements. Specifically, under UK/SISI guidelines, advisors have a duty to avoid conflicts of interest or, if unavoidable, disclose them fully and manage them appropriately to ensure clients are not disadvantaged. The correct approach involves transparent disclosure of the incentive to the client and the firm, and then seeking the client's informed consent, or declining to recommend the product if the conflict cannot be adequately managed. This upholds the advisor's duty of care and loyalty. An incorrect approach that involves accepting the incentive and recommending the product without full disclosure to the client or firm is a clear breach of regulatory and ethical standards. This constitutes misrepresentation and potentially fraud, as the client is not aware of the advisor's personal gain, leading to a decision based on incomplete information. Another incorrect approach, accepting the incentive but only recommending the product if it is genuinely the best option for the client, is still problematic. While the intention might seem client-centric, the presence of the incentive creates an inherent bias that is difficult to overcome, and the lack of full disclosure to the client and firm means the conflict is not being managed transparently, violating the duty of disclosure and potentially leading to a breach of fiduciary duty if the product is not demonstrably superior. A third incorrect approach, declining the incentive but proceeding with the recommendation without any disclosure, fails to address the potential for perceived bias or the firm's internal policies on such inducements, and misses an opportunity for transparent practice. The professional decision-making process for similar situations should involve a clear framework. 1. Identify the potential conflict of interest. 2. Assess the nature and severity of the conflict. 3. Consult relevant regulatory codes of conduct and firm policies. 4. Determine if the conflict can be avoided or effectively managed. 5. If management is possible, implement transparent disclosure to all relevant parties, client, firm. 6. Obtain informed consent where required. 7. If the conflict cannot be managed ethically or transparently, decline to proceed with the action that creates the conflict. 8. Document all decisions and actions taken. Question 8. Quality control measures reveal that a financial advisor has processed a series of unusually large cash deposits for a client who has recently experienced a significant, unexplained increase in wealth. The client's stated source of funds appears inconsistent with their known business activities, and the advisor has noted the client's evasiveness when questioned about the origin of these funds. The firm's internal AML policy mandates a risk-based approach to identifying and reporting suspicious transactions. What is the most appropriate course of action for the financial advisor and the firm in this situation? Option A. Inform the client directly that their transactions are being flagged as suspicious and that a SAR may be filed. Option B. Immediately file a suspicious activity report (SAR) with the relevant regulatory authorities based on the initial observations, without further internal investigation. Option C. Continue processing the transactions as usual, assuming the client's explanations are sufficient, and avoid raising internal concerns to maintain client relationships. Option D. Conduct a thorough internal review of the client's transaction history and the advisor's interactions, escalating any confirmed red flags to the firm's Money Laundering Reporting Officer, MLRO, for further assessment and potential suspicious activity report, SAR, filing. Correct answer is D. Conduct a thorough internal review of the client's transaction history and the advisor's interactions, escalating any confirmed red flags to the firm's Money Laundering Reporting Officer, MLRO, for further assessment and potential suspicious activity report, SAR, filing. Explanation. This scenario presents a professional challenge due to the inherent conflict between client confidentiality and the regulatory obligation to report suspicious activities. The firm must navigate the delicate balance of protecting client information while upholding its duty to prevent financial crime. Careful judgment is required to determine when suspicion crosses the threshold into a reportable event, avoiding both over-reporting, which can burden regulators and damage client relationships, and underreporting, which can lead to regulatory sanctions and facilitate illicit activities. The correct approach involves a thorough internal investigation, gathering sufficient information to form a reasonable suspicion that a client is involved in money laundering or terrorist financing. This aligns with the regulatory framework's emphasis on a risk-based approach and the requirement for firms to have robust anti-money laundering (AML) systems and controls. By escalating the matter internally for further review by the compliance department, the firm demonstrates due diligence and adherence to its AML obligations. This process ensures that any suspicious activity report, SAR, filed is well-founded, supported by evidence, and meets the threshold for reporting, thereby fulfilling the firm's legal and ethical duties without prematurely breaching client confidentiality. An incorrect approach of immediately filing a SAR without further internal investigation is professionally unacceptable. This would likely constitute a breach of client confidentiality without sufficient grounds, potentially damaging the client relationship and the firm's reputation. It also fails to utilize the firm's internal AML resources and processes designed to assess and manage risk. Furthermore, filing a SAR based on mere speculation rather than reasonable suspicion can lead to unnecessary regulatory scrutiny and may be considered an abuse of the reporting system. Another incorrect approach of ignoring the red flags and continuing to facilitate transactions would be a severe regulatory and ethical failure. This directly contravenes the firm's AML obligations and could result in significant penalties, including fines and reputational damage. It demonstrates a lack of commitment to preventing financial crime and a disregard for the firm's responsibilities under the law. A third incorrect approach of informing the client directly about the suspicion and the potential for reporting is also professionally unacceptable. This is known as tipping off and is a criminal offense in many jurisdictions. It would alert the suspected individuals, allowing them to evade detection and potentially destroy evidence, thereby undermining the entire AML framework. Professional decision-making process for similar situations should involve a structured approach. 1. Recognize and document potential red flags. 2. Initiate internal inquiries to gather more information. 3. Consult with the firm's designated AML compliance officer or MLRO, Money Laundering Reporting Officer. 4. Assess the gathered information against the established criteria for reasonable suspicion of money laundering or terrorist financing. 5. If reasonable suspicion is formed, proceed with filing a SAR through the appropriate channels. 6. Maintain detailed records of all steps taken and decisions made. Question 9. During the evaluation of a high net worth client's portfolio, the client expresses a strong desire to invest a significant portion of their assets into a highly speculative, illiquid asset class that has recently experienced a surge in popularity, but lacks a long-term track record and carries substantial risk of capital loss. The client is insistent, citing anecdotal evidence and the potential for rapid gains. As the financial advisor, you have identified that this investment is not aligned with the client's stated long-term financial goals, risk tolerance, or the regulatory suitability requirements for their profile. What is the most appropriate course of action? Option A. Conduct a thorough risk assessment of the proposed investment. Clearly explain to the client the significant risks involved, the potential for capital loss, and how it conflicts with their stated financial objectives and regulatory suitability. Present alternative. More suitable investment strategies that align with their goals and risk profile, and document the entire discussion and the client's final decision. Option B. Proceed with the investment as requested by the client, but omit any detailed discussion of the risks to avoid alarming them, focusing only on the potential for high returns. Option C. Advise the client that the investment is too risky and refuse to proceed with the transaction without exploring the client's motivations or offering alternative solutions. Option D. Immediately execute the client's requested investment to maintain client satisfaction and avoid potential loss of business, while briefly mentioning the speculative nature of the asset. Correct answer is A. Conduct a thorough risk assessment of the proposed investment. Clearly explain to the client the significant risks involved, the potential for capital loss, and how it conflicts with their stated financial objectives and regulatory suitability. Present alternative, more suitable investment strategies that align with their goals and risk profile, and document the entire discussion and the client's final decision. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent conflict between a client's stated wishes and the advisor's fiduciary duty to act in the client's best interest, particularly when those wishes might lead to suboptimal outcomes or regulatory breaches. The advisor must navigate the complexities of client autonomy versus professional responsibility, ensuring that advice is both compliant and truly beneficial. The pressure to retain a client, especially one with significant assets, can also create an ethical dilemma, requiring a strong commitment to professional standards over commercial expediency. Correct approach analysis. The correct approach demonstrates best professional practice by prioritizing the client's long-term financial well-being and regulatory compliance. It involves a thorough understanding of the client's objectives, a clear explanation of the risks and benefits of different strategies, and a commitment to providing advice that aligns with regulatory requirements and ethical obligations. This approach upholds the fiduciary duty by ensuring that recommendations are objective, suitable, and in the client's best interest, even if it means challenging the client's initial inclination. It also involves documenting the advice and the client's decision-making process, which is crucial for accountability and compliance. Incorrect approaches analysis. One incorrect approach involves immediately agreeing to the client's request without further investigation. This fails to uphold the fiduciary duty, as it prioritizes client satisfaction over the client's actual best interest and regulatory suitability requirements. It could lead to the client making a decision that is detrimental to their financial future or violates regulatory guidelines, exposing both the client and the advisor to significant risks. Another incorrect approach is to dismiss the client's request outright without understanding the underlying reasons or exploring alternatives. This demonstrates a lack of client centricity and can damage the professional relationship. While the client's initial idea may be flawed, a professional should engage in a dialogue to understand their motivations and then guide them towards more appropriate solutions, rather than simply shutting down the conversation. This approach risks alienating the client and failing to provide valuable, tailored advice. A third incorrect approach is to proceed with the client's request while downplaying the associated risks or failing to adequately disclose them. This constitutes a breach of the duty of care and transparency. Professionals are obligated to provide a full and fair picture of potential downsides, allowing the client to make an informed decision. Concealing or minimizing risks is unethical and can lead to severe regulatory penalties and reputational damage. Professional reasoning. Professionals should adopt a structured decision-making process that begins with a comprehensive understanding of the client's situation, objectives, and risk tolerance. This is followed by an objective assessment of various strategies, considering their suitability, regulatory compliance, and potential outcomes. Open and honest communication with the client is paramount, involving a clear explanation of recommendations, risks, and alternatives. The professional must then document the advice given and the client's final decision, ensuring that all actions are defensible and aligned with professional standards and regulatory frameworks. The ultimate goal is to empower the client to make informed decisions that serve their best interests within the bounds of the law and ethical practice. Question 10. System analysis indicates a client who has previously invested in a range of diversified equity funds, expresses a strong interest in a new, highly complex structured product offering leveraged exposure to emerging market currencies. The client states they are seeking high returns and are comfortable with significant risk. The product documentation is extensive and technical. What is the most appropriate course of action for the financial advisor? Option A. Proceed with the investment as requested by the client, given their stated interest and previous experience with riskier investments, and provide them with the product documentation to review. Option B. Conduct a detailed assessment of the client's financial situation, investment objectives, and risk tolerance, and then provide a clear, comprehensive explanation of the structured product's features, risks, potential returns, and downsides, ensuring the client understands the implications before proceeding. Option C. Advise the client that due to the complexity of the product, it is likely beyond their current understanding and suggest they consider simpler investment alternatives. Option D. Present a summary of the product's potential high returns and briefly mention that it involves some risk, assuming the client's stated comfort with risk means they will understand the implications. The correct answer is B. Conduct a detailed assessment of the client's financial situation, investment objectives, and risk tolerance, and then provide a clear, comprehensive explanation of the structured product's features, risks, potential returns, and downsides, ensuring the client understands the implications before proceeding. Explanation. Scenario analysis. This scenario presents a professional challenge involving the interpretation and application of regulatory requirements concerning client suitability and disclosure. The challenge lies in balancing the client's stated investment objectives with the inherent risks of a complex financial product, and ensuring that all material information is communicated effectively and transparently. A failure to do so could lead to regulatory breaches, client dissatisfaction, and reputational damage. Careful judgment is required to assess whether the proposed investment truly aligns with the client's profile, and if the disclosure provided is adequate and understandable. Correct approach analysis. The correct approach involves a thorough assessment of the client's financial situation, investment objectives, and risk tolerance, followed by a clear and comprehensive explanation of the product's features, risks, and potential downsides. This aligns with the fundamental principles of client-centric advice and regulatory obligations to act in the client's best interest. Specifically, it adheres to the principles of Know Your Client (KIC) and suitability, ensuring that any recommendation is appropriate for the individual. Transparent disclosure of all material facts, including potential losses, is paramount to enabling informed decision-making by the client, fulfilling the duty of care, and preventing misrepresentation. Incorrect approaches analysis. One incorrect approach involves proceeding with the investment solely based on the client's explicit request, without a deeper investigation into the suitability of the product. This fails to uphold the professional duty to ensure the investment is appropriate for the client's circumstances, potentially violating suitability rules. Prioritizes client instruction over professional responsibility, which is a significant regulatory and ethical failure. Another incorrect approach is to provide a superficial overview of the product, highlighting only its potential benefits while downplaying or omitting the associated risks. This constitutes a failure in transparent disclosure and can be considered misleading. It breaches the ethical obligation to provide complete and accurate information, and contravenes regulations that mandate full disclosure of material risks. A third incorrect approach is to assume the client fully understands the complex product due to their stated experience, without verifying their comprehension. This overlooks the professional responsibility to ensure clarity and understanding, especially with sophisticated or high-risk instruments. It can lead to a situation where the client agrees to an investment they do not fully comprehend, creating a basis for future disputes and regulatory scrutiny. Professional reasoning. Professionals should adopt a structured decision-making process that begins with a comprehensive understanding of the client's profile. This should be followed by a rigorous evaluation of any proposed product against that profile, considering its alignment with objectives and risk tolerance. Crucially, all risks and benefits must be communicated clearly and understandably, with mechanisms in place to confirm client comprehension. If any doubt exists regarding suitability or understanding, further discussion, clarification, or alternative recommendations are necessary. This process prioritizes client welfare and regulatory compliance, fostering trust and long-term relationships. Question 11. Compliance review shows that Astra International is planning to launch a new investment product that utilizes advanced algorithmic trading strategies. While the product promises significant potential returns, the internal review process has not yet fully assessed its alignment with the firm's existing regulatory obligations concerning client suitability, data privacy, and marketing disclosures. What is the most appropriate next step for Astra International? Option A. Prioritize the product's rapid market introduction and address any compliance concerns that may arise after the launch. Option B. Proceed with the product launch, assuming that the firm's general compliance policies will adequately cover any potential issues. Option C. Conduct a comprehensive regulatory impact assessment for the new product, ensuring it meets all relevant compliance requirements before launch. Option D. Rely solely on the legal department's review of the product's documentation to ensure it is legally sound. The correct answer is C. Conduct a comprehensive regulatory impact assessment for the new product, ensuring it meets all relevant compliance requirements before launch. Explanation. Scenario analysis. This scenario presents a common challenge in regulatory compliance, where a new, seemingly beneficial product is introduced without adequate consideration for its potential impact on existing regulatory obligations. The challenge lies in balancing innovation and business growth with the imperative to maintain strict adherence to compliance frameworks. The firm must proactively identify and address potential regulatory gaps before market launch, rather than reactively correcting issues after they arise, which can lead to significant reputational damage, fines, and operational disruption. Correct approach analysis. The correct approach involves a comprehensive review of the new product against all applicable regulatory requirements, including those related to client suitability, data privacy, and marketing. This proactive due diligence ensures that the product's design and rollout align with the firm's compliance obligations, thereby mitigating risks. This represents best professional practice because it embodies the principle of compliance by design, embedding regulatory considerations from the outset. It demonstrates a commitment to ethical conduct and client protection, which are foundational to maintaining trust and integrity in the financial services industry. Specifically, it aligns with the principles of robust risk management and the duty to act in the best interests of clients, as mandated by regulatory bodies. Incorrect approaches analysis. One incorrect approach involves proceeding with the product launch based on the assumption that existing general compliance policies are sufficient. This fails to acknowledge that new products may introduce novel risks or interact with regulations in unforeseen ways. It represents a failure in due diligence and a potential breach of specific regulatory requirements that mandate tailored assessments for new offerings. This approach risks violating regulations concerning product suitability and risk disclosure. Another incorrect approach is to rely solely on the legal department's review without involving the compliance team. While legal counsel advises on the legality of actions, compliance officers are specialized in interpreting and applying regulatory frameworks to business operations. This division of responsibility can lead to overlooking nuanced compliance requirements that fall outside purely legal interpretation, such as specific conduct rules or reporting obligations. This can result in a failure to meet the spirit, not just the letter, of the law. A third incorrect approach is to prioritize speed to market over thorough regulatory vetting, intending to address any compliance issues post-launch. This is a high-risk strategy that disregards the proactive nature of regulatory compliance. It can lead to significant penalties, client remediation costs, and severe reputational damage. Ethically, it demonstrates a disregard for client protection and regulatory integrity, prioritizing commercial gain over responsible business conduct. Professional reasoning. Professionals should adopt a systematic and proactive approach to regulatory compliance. This involves establishing clear internal processes for new product development that mandate early and continuous engagement with compliance and legal teams. A risk-based assessment framework should be applied to identify potential compliance issues, and mitigation strategies should be developed and implemented before launch. Regular training and updates on regulatory changes are also crucial. In situations involving new products, the decision-making process should prioritize a thorough understanding of the regulatory landscape, potential client impact, and the firm's risk appetite, ensuring that all actions are defensible and aligned with ethical standards and regulatory expectations. Question 12. Regulatory review indicates that a long-standing, high-net-worth client has recently engaged in a series of complex international transactions that deviate significantly from their historical financial behavior. While the client has provided a plausible, albeit vague, explanation for these transactions, the compliance officer has a nagging concern that the underlying purpose might be to obscure the origin or destination of funds. What is the most appropriate course of action for the compliance officer to take in accordance with UK regulatory requirements? Option A. Immediately file a Suspicious Activity Report (SAR) with the National Crime Agency (NCA), given the deviation from historical patterns and the potential for illicit activity. Option B. Inform the client directly that their recent transactions have raised concerns about potential money laundering and inquire further about the specifics to alleviate the firm's suspicions. Option C. Conduct a detailed internal investigation into the client's transaction history and the provided explanation, documenting all findings and consulting with the firm's MLRO and legal counsel before making a decision on whether to file a suspicious activity report, SAR. Option D. Rely on the client's established relationship and their provided explanation, considering the transactions unusual but not sufficiently suspicious to warrant further action or reporting. The correct answer is C. Conduct a detailed internal investigation into the client's transaction history and the provided explanation, documenting all findings and consulting with the firm's MLRO and legal counsel before making a decision on whether to file a suspicious activity report, SAR. Explanation. Scenario analysis. This scenario presents a challenge in balancing client confidentiality with the regulatory obligation to report suspicious activities. The compliance officer must exercise sound judgment to determine if the client's actions constitute a genuine suspicion of money laundering, or if they are merely unusual but not indicative of illicit intent. Misinterpreting the situation could lead to either a failure to report a crime or an unwarranted breach of client trust and potential reputational damage for the firm. Correct approach analysis. The correct approach involves a thorough, documented investigation into the client's transaction patterns and the underlying business rationale. This aligns with the principles of Know Your Customer (KIC) and anti-money laundering (AML) regulations, which mandate that financial institutions establish robust systems for identifying and reporting suspicious transactions. By gathering evidence and consulting with internal legal and compliance teams, the officer ensures that any reporting is based on reasonable suspicion, fulfilling regulatory duties while minimizing the risk of unfounded accusations. This methodical process is crucial for demonstrating due diligence and adherence to the Proceeds of Crime Act 2002 and the Money Laundering Regulations 2017. Incorrect approach is analysis. Failing to investigate further and immediately filing a suspicious activity report, SAR, without sufficient evidence constitutes a failure to exercise professional judgment. This could lead to unnecessary regulatory scrutiny for both the client and the firm, potentially damaging client relationships and wasting law enforcement resources. It also risks violating the principle of proportionality in regulatory reporting. Ignoring the unusual transaction pattern due to the client's long-standing relationship and perceived trustworthiness is a significant ethical and regulatory failure. This approach neglects the ongoing duty of vigilance required by AML regulations. Trust, while important, cannot override the obligation to monitor for and report suspicious activity. As per the FCA's principles for businesses, particularly Principle 3, Financial Stability, and Principle 7, Communications with Clients. Consulting with the client directly about the suspected money laundering activity before reporting is a severe breach of confidentiality and regulatory procedure. This action could tip off the client, allowing them to conceal or destroy evidence, thereby obstructing a potential investigation and violating the tipping-off provisions within the Proceeds of Crime Act 2002. Professional reasoning. Professionals should adopt a structured approach to compliance issues. This involves 1. Understanding the relevant regulatory framework, e.g., POCA 2002, MLR 2017, FCA Handbook. 2. Gathering all relevant facts and evidence objectively. 3. Assessing the facts against regulatory thresholds for suspicion. 4. Documenting the entire process, including the rationale for any decision. 5. Seeking internal guidance from legal and compliance experts when uncertainty exists. 6. Acting with integrity and prioritizing regulatory obligations while maintaining client relationships where possible and appropriate. Question 13. Governance review demonstrates that the firm's current customer onboarding process, while efficient in terms of speed, has not been updated to reflect evolving regulatory expectations for a risk-based approach to anti-money laundering (AML) and counter-terrorist financing (CTF). Specifically, the process applies a uniform level of due diligence to all new clients, irrespective of their geographical origin, business activities, or the complexity of their ownership structure. This approach risks overlooking high-risk clients and transactions, potentially exposing the firm to financial crime, Which of the following represents the most appropriate regulatory compliance strategy for the firm? Option A. Continue with the current standardized onboarding process, focusing on staff training to identify obvious red flags, as the regulatory burden of a full risk-based approach is deemed too costly and time-consuming. Option B. Delegate the entire customer due diligence process to an external third-party provider without establishing clear oversight or performance metrics, assuming they are fully compliant with all relevant regulations. Option C. Implement a tiered customer due diligence framework that categorizes clients based on risk factors and applies enhanced due diligence measures to those identified as higher risk, while ensuring all clients undergo a baseline level of verification. Option D. Reduce the level of due diligence required for clients originating from jurisdictions with perceived lower AML/CTF risks to expedite onboarding and increase market penetration in those regions. The correct answer is C. Implement a tiered customer due diligence framework that categorizes clients based on risk factors and applies enhanced due diligence measures to those identified as higher risk, while ensuring all clients undergo a baseline level of verification. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent conflict between a firm's desire to expand its client base and the stringent regulatory obligations to conduct thorough due diligence. The pressure to onboard new clients quickly, especially in a competitive market, can lead to shortcuts that compromise regulatory compliance. The firm must balance commercial objectives with its legal and ethical responsibilities to prevent financial crime and maintain market integrity. Correct approach analysis. The correct approach, which involves implementing a robust risk-based customer due diligence (CDD) process that includes enhanced due diligence for high-risk clients, represents best professional practice. This aligns directly with the principles of the UK's Money Laundering Regulations (MLR) and the Financial Conduct Authority (FCA) Handbook, particularly CISC 6, 1R and CISC 6, 3, 1R, which mandate firms to have adequate systems and controls to prevent financial crime. A risk-based approach allows firms to allocate resources effectively, focusing more scrutiny on clients and transactions that pose a greater risk of money laundering or terrorist financing, thereby ensuring compliance without unduly hindering legitimate business. Incorrect approaches analysis. One incorrect approach would be to rely solely on a standardized, low-level CDD process for all new clients, regardless of their perceived risk profile. This fails to meet the regulatory requirement for a risk-based approach. The MLRs and FCA guidance emphasize that a one-size-fits-all approach is insufficient, as it may not identify or mitigate the specific risks associated with certain clients or jurisdictions. This could lead to the firm inadvertently facilitating financial crime, resulting in significant regulatory sanctions, reputational damage, and potential criminal liability. Another incorrect approach would be to delegate the entire CDD process to junior staff without adequate training, supervision, or clear escalation procedures for suspicious findings. This violates the principle of adequate systems and controls. The FCA expects firms to have competent personnel and effective oversight. Inadequate training can lead to missed red flags, while a lack of supervision can result in noncompliance going unnoticed. This approach increases the risk of regulatory breaches and the firm being used for illicit purposes. A third incorrect approach would be to prioritize speed of onboarding over the thoroughness of due diligence, accepting incomplete documentation or relying on self-certification without independent verification for high-risk clients. This directly contravenes the spirit and letter of the MLRs, which require reasonable steps to verify customer identity and understand the nature of their business. Such a practice exposes the firm to significant risks and demonstrates a disregard for regulatory obligations. Professional reasoning. Professionals should adopt a decision-making process that begins with understanding the firm's regulatory obligations under the relevant framework, in this case, UK MLRs and FCA rules. They should then assess the inherent risks associated with different client types, products, and geographical locations. Based on this risk assessment, a proportionate and risk-based CDD policy and procedure should be developed and implemented. Continuous training, robust internal controls, and regular reviews of the effectiveness of these systems are crucial. When faced with pressure to onboard clients quickly, professionals must remember that regulatory compliance is non-negotiable, and that the long-term consequences of non-compliance far outweigh any short-term commercial gains. Question 14. System analysis indicates that a financial institution is reviewing a new client application for a complex international trading business. The client's stated purpose for the account is to facilitate frequent, high-value transactions across multiple jurisdictions. Given the potential for increased risk associated with such activities, what is the most appropriate regulatory compliance approach to ensure adherence to anti-money laundering (AML) and know your customer (KIC) obligations? Option A. Implement enhanced due diligence measures, including verifying the source of funds and wealth, understanding the client's business rationale for the transaction volume, and conducting ongoing monitoring of the account activity. Option B. Proceed with the transaction based on the client's stated purpose, assuming the business is legitimate, and conduct only basic identity verification. Option C. Rely exclusively on automated screening tools to flag any potential risks, without further human review or investigation. Option D. Apply the most stringent level of due diligence to all new clients, irrespective of their risk profile, to ensure maximum compliance. The correct answer is A. Implement enhanced due diligence measures, including verifying the source of funds and wealth, understanding the client's business rationale for the transaction volume, and conducting ongoing monitoring of the account activity. Explanation. Scenario analysis. This scenario presents a common challenge in regulatory compliance where a firm must balance the need for efficient client onboarding with the stringent requirements of anti-money laundering (AML) regulations. The pressure to meet business targets can create a temptation to streamline processes, potentially at the expense of thorough due diligence. The professional challenge lies in identifying and mitigating the risks associated with inadequate Know Your Customer (KIC) procedures, while ensuring the firm remains competitive and client-friendly. This requires a nuanced understanding of regulatory intent and the practical implications of compliance failures. Correct approach analysis. The correct approach involves a risk-based assessment of the client and the transaction. This aligns directly with the principles of modern AML regulations, which emphasize proportionality and effectiveness. By tailoring the level of due diligence to the perceived risk, the firm can allocate resources efficiently while still meeting its obligations. This approach allows for a more agile and responsive compliance framework, capable of adapting to different client profiles and transaction types. It demonstrates a commitment to robust compliance by prioritizing thoroughness where risk is higher, thereby protecting the firm from financial crime and reputational damage, and upholding the integrity of the financial system. This is best professional practice as it is mandated by regulatory frameworks that expect firms to implement risk-sensitive controls. Incorrect approaches analysis. One incorrect approach involves proceeding with the transaction without any additional due diligence, relying solely on the client's stated purpose. This is a significant regulatory and ethical failure. It demonstrates a disregard for the fundamental principles of AML/KYC, which require verification of client identity and understanding of the nature of their business and transaction. This approach exposes the firm to the risk of facilitating money laundering or terrorist financing, leading to severe penalties, including fines, sanctions, and reputational ruin. It also violates the ethical duty to act with integrity and to prevent the misuse of financial services. Another incorrect approach is to apply the most stringent level of due diligence to every single client, regardless of risk. While seemingly cautious, this is inefficient and can be detrimental to client relationships and business operations. It fails to adhere to the risk-based approach mandated by regulations, which allows for proportionality. Overly burdensome procedures for low-risk clients can lead to unnecessary costs, delays, and a poor client experience, potentially driving business to less compliant competitors. Ethically, it represents a misallocation of resources that could be better directed towards high-risk areas. A third incorrect approach is to rely solely on automated checks without any human oversight or critical assessment. While automation is a valuable tool, it cannot replace the judgment and experience of compliance professionals. Automated systems may miss subtle red flags or fail to interpret complex scenarios accurately. This approach creates a false sense of security and can lead to compliance gaps, as it lacks the qualitative assessment necessary to identify sophisticated money laundering schemes. It represents a failure to implement effective controls and a potential breach of regulatory expectations for a robust compliance program. Professional reasoning. professionals should adopt a risk-based approach to AML/KYC. This involves 1. Understanding the client and their business. Gather information about the client's identity, ownership structure, business activities, and the intended nature of the business relationship. 2. Assessing the risk. Evaluate factors such as the client's geographic location, industry, transaction patterns, and the source of funds/wealth. 3. Tailoring due diligence. Apply enhanced due diligence for high-risk clients and simplified due diligence for low-risk clients, always ensuring minimum standards are met. 4. Ongoing monitoring. Continuously monitor client transactions and relationships for any suspicious activity. 5. Escalation and reporting. Establish clear procedures for escalating suspicious activity to senior management and for reporting to the relevant authorities when necessary. This systematic process ensures compliance with regulatory requirements, mitigates financial crime risks, and upholds ethical standards. Question 15. Implementation of a robust anti-money laundering. AML framework requires financial institutions to be vigilant in identifying and reporting suspicious transactions. If a relationship manager at Astra International observes a pattern of transactions that, while not explicitly illegal on their own, raise concerns about potential money laundering due to their unusual nature and lack of clear economic purpose, what is the most appropriate course of action to ensure regulatory compliance? Option A. Immediately file a suspicious activity report (SAR) with the relevant regulatory body based on the initial concerns. Option B. Discuss the observed transaction patterns directly with the client to understand their business rationale. Option C. Conduct a discrete internal investigation to gather more information and assess the likelihood of money laundering before escalating the matter. Option D. Ignore the transactions as they do not appear to be explicitly illegal, and there is no direct evidence of criminal activity. The correct answer is A. Immediately file a suspicious activity report (SAR) with the relevant regulatory body based on the initial concerns. Explanation. This scenario presents a professional challenge due to the inherent tension between client confidentiality and the regulatory obligation to report suspicious activities. Astra International, as a financial institution, is bound by strict anti-money laundering (AML) regulations. The challenge lies in balancing the duty to protect client information with the imperative to prevent financial crime. A failure to report can lead to severe penalties for the firm and individuals involved, while an unfounded report can damage client relationships and reputation. The correct approach represents best professional practice because it adheres to the established regulatory framework for AML compliance. It involves a systematic process of escalation and investigation, ensuring that suspicions are not ignored but are handled through appropriate channels. This approach prioritizes regulatory obligations while also seeking to gather sufficient information to make an informed decision, thereby minimizing the risk of both a missed report and an unjustified one. It demonstrates due diligence and a commitment to upholding the integrity of the financial system. An incorrect approach that involves ignoring the suspicious activity or dismissing it without proper investigation constitutes a direct breach of AML regulations. This failure to identify and report suspicious transactions is a serious regulatory and ethical lapse, potentially enabling money laundering and other financial crimes. Another incorrect approach, such as immediately reporting the suspicion to the authorities without any internal review or gathering of further information, could be premature and potentially damaging to the client's reputation if the suspicion is unfounded. This might also violate internal policies regarding the escalation of such matters and could be seen as an overreaction without due diligence. A third incorrect approach, such as discussing the suspicion with the client directly before reporting, is a severe breach of confidentiality and can tip off the client, hindering any potential investigation and leading to severe regulatory sanctions. The professional decision-making process for similar situations should involve a clear understanding of the firm's AML policies and procedures. When a suspicious activity is identified, the professional should first document all relevant details. Then they should consult internal compliance resources or their supervisor to assess the situation against regulatory red flags. If the suspicion persists after internal review, the next step is to follow the prescribed reporting channels, which typically involves filing a suspicious activity report (SAR) with the relevant regulatory authority. This structured approach ensures that all obligations are met and that decisions are made based on a thorough assessment of the facts and regulatory requirements. Question 16. Quality control measures reveal that a financial advisor has recommended a specific investment product to a client. The advisor's rationale for this recommendation is primarily based on the product being part of the firm's preferred provider list and contributing significantly to the advisor's quarterly sales target. The compliance officer is reviewing this recommendation. Which of the following actions by the compliance officer best upholds regulatory and ethical standards? Option A. Reject the recommendation and request the advisor to provide a detailed justification for why this specific product is demonstrably the most suitable option for the client, considering their stated financial objectives and risk profile, independent of any internal lists or targets. Option B. Approve the recommendation with a note that the advisor should be mindful of sales targets in future recommendations, acknowledging that meeting targets is a key performance indicator for advisors. Option C. Approve the recommendation, as it aligns with the firm's preferred provider strategy and helps the advisor meet their sales target, which is crucial for the firm's overall performance. Option D. Approve the recommendation, assuming that the preferred provider list has already undergone a suitability assessment by the firm, making individual product suitability checks redundant for these products. The correct answer is C. Approve the recommendation, as it aligns with the firm's preferred provider strategy and helps the advisor meet their sales target, which is crucial for the firm's overall performance. Explanation. Scenario analysis. This scenario presents a professional challenge related to the integrity of financial advice and the potential for conflicts of interest. The challenge lies in balancing the firm's commercial interests with the fiduciary duty owed to clients. The compliance officer must exercise careful judgment to ensure that recommendations are genuinely in the client's best interest, not influenced by internal sales targets or preferred product lists. The pressure to meet targets can create an environment where compliance is seen as an obstacle rather than a safeguard. Correct approach analysis. The correct approach involves a thorough review of the client's financial situation, objectives, and risk tolerance, independently of any internal sales targets or preferred product lists. This aligns with the regulatory framework for financial advice, which mandates that recommendations must be suitable for the client. Specifically, under the FCA's Conduct of Business Sourcebook, COBS, firms have a duty to act honestly, fairly, and professionally in accordance with the best interests of their clients. This includes ensuring that products recommended are appropriate and that any conflicts of interest are managed. The compliance officer's role is to verify that these principles have been adhered to, ensuring that the client's needs are paramount. Incorrect approaches analysis. One incorrect approach is to approve the recommendation solely because it meets the firm's internal sales target. This represents a significant regulatory and ethical failure. It prioritizes the firm's commercial gain over the client's welfare, violating the principle of acting in the client's best interests as required by COBS. This could lead to the client receiving unsuitable advice, potentially resulting in financial loss and regulatory sanctions for the firm. Another incorrect approach is to approve the recommendation because it is a product from a preferred provider list, without independently verifying its suitability. While preferred provider lists can exist for efficiency, they must not override the fundamental requirement of suitability. Relying solely on such a list without due diligence is a failure to conduct proper client assessment and product suitability checks, contravening COBS requirements. This approach risks recommending products that, while perhaps familiar to the firm, are not the most appropriate for the specific client's circumstances. A third incorrect approach is to approve the recommendation without a clear understanding of the client's financial objectives. Financial advice must be tailored to individual goals, such as retirement planning, capital growth, or income generation. Approving a recommendation without this understanding means the advice is not personalized and therefore not suitable, a direct breach of regulatory expectations under COBS. Professional reasoning. Professionals in this situation should adopt a decision-making framework that prioritizes client welfare and regulatory compliance. This involves 1. Understanding the client's needs. Always begin with a comprehensive assessment of the client's financial situation, objectives, risk tolerance, and knowledge. 2. Independent product assessment. Evaluate potential products based on their suitability for the client, not on internal targets or preferred lists. 3. Conflict of interest management. Identify and disclose any potential conflicts of interest and ensure they do not compromise client advice. 4. Regulatory adherence. Constantly refer to and apply relevant regulations such as the FCA's COBs to ensure all actions are compliant. 5. Escalation. If there is any doubt about suitability or compliance, escalate the matter to senior management or the compliance department for further review. Question 17. Operational review demonstrates that the firm's current client onboarding process for a new segment of high net worth individuals may not fully capture the ultimate beneficial ownership details required by the UK's Money Laundering Regulations 2017. The sales team is eager to onboard these clients quickly due to significant anticipated revenue. Which of the following actions best upholds regulatory compliance and professional integrity? Option A. Advise the sales team to proceed with onboarding, but to informally gather additional beneficial ownership information from clients during subsequent interactions, without formalizing the process. Option B. Immediately escalate the findings to the compliance and risk management departments for a thorough review and the development of enhanced verification procedures before onboarding any new clients from this segment. Option C. Proceed with onboarding the clients using the existing, potentially insufficient, verification procedures, with a plan to address any identified issues retrospectively if they arise. Option D. Implement a simplified verification process for this client segment, focusing on readily available information to expedite onboarding while acknowledging the potential for minor deviations from full beneficial ownership requirements. The correct answer is B. Immediately escalate the findings to the compliance and risk management departments for a thorough review and the development of enhanced verification procedures before onboarding any new clients from this segment. Explanation. This scenario presents a professional challenge due to the inherent conflict between achieving business objectives and upholding regulatory compliance. The firm's operational review has identified a potential gap in its anti-money laundering (AML) procedures, specifically concerning the verification of beneficial ownership for a new class of clients. The pressure to onboard these clients quickly, driven by market opportunities, creates a tension that requires careful judgment to ensure that compliance is not sacrificed for expediency. The correct approach involves immediately escalating the identified AML gap to the relevant compliance and risk management departments for thorough investigation and remediation. This aligns with the principles of robust regulatory compliance, particularly under frameworks like the UK's Proceeds of Crime Act 2002 and the Financial Conduct Authority's (FCA) money laundering regulations. These regulations mandate that firms have adequate systems and controls in place to prevent financial crime. Prompt escalation ensures that the issue is addressed at the appropriate level, allowing for the development and implementation of compliant procedures before any potential breaches occur. This proactive stance demonstrates a commitment to ethical conduct and regulatory adherence, safeguarding the firm's reputation and avoiding potential penalties. An incorrect approach would be to proceed with onboarding the clients without fully resolving the AML verification concerns, relying on a wait-and-see attitude or assuming existing, albeit potentially inadequate, procedures are sufficient. This directly contravenes the Know Your Customer (KIC) and beneficial ownership verification requirements central to AML legislation. Such an approach risks facilitating money laundering or terrorist financing, leading to severe regulatory sanctions, including substantial fines and reputational damage. Another incorrect approach would be to implement a superficial fix, such as a simplified verification process that does not meet the regulatory standard for identifying beneficial owners. This demonstrates a lack of due diligence and a failure to understand the spirit and intent of AML regulations, which are designed to be robust and comprehensive. The professional decision-making process in such situations should involve a clear understanding of the firm's regulatory obligations, a commitment to ethical conduct, and a structured approach to risk management. When an operational review identifies a potential compliance gap, the immediate steps should be: 1. Document the finding thoroughly. 2. Assess the potential impact and risk associated with the gap. 3. Escalate the issue to the appropriate internal stakeholders, e.g., compliance, legal, risk management. 4. Collaborate on developing and implementing a compliance solution. 5. Monitor the effectiveness of the implemented solution. This systematic process ensures that identified risks are managed effectively and that the firm operates within the bounds of the law and ethical standards. Question 18. The audit findings indicate a pattern of inconsistent application of data access controls for sensitive client information, leading to potential breaches of confidentiality and regulatory reporting requirements. The firm's internal compliance team has flagged this as a significant risk. What is the most appropriate immediate course of action to address these findings? Option A. Instruct the IT department to conduct a superficial review of access logs and make minor adjustments to user permissions without a full investigation into the underlying procedural or systemic issues. Option B. Advise the relevant regulatory bodies of the potential breaches and await their guidance on how to proceed with corrective actions. Option C. Immediately implement a blanket restriction on all access to sensitive client data until a new, more stringent access control system can be procured and installed. Option D. Initiate a comprehensive internal investigation to identify the root causes of the inconsistent data access control application, document all findings, and develop a remediation plan that includes policy updates and staff training. The correct answer is D. Initiate a comprehensive internal investigation to identify the root causes of the inconsistent data access control application, document all findings, and develop a remediation plan that includes policy updates and staff training. Explanation. The audit findings indicate a potential breach of regulatory compliance related to the handling of client information and internal data security protocols. This scenario is professionally challenging because it requires balancing the immediate need to address the audit findings with the long-term implications for client trust, regulatory standing, and the firm's operational integrity. A careful judgment is required to determine the most appropriate course of action that upholds the firm's commitment to regulatory adherence and ethical conduct. The correct approach involves a thorough, documented investigation into the root cause of the data handling discrepancies, followed by the implementation of corrective actions and a review of existing policies and procedures. This represents best professional practice because it directly addresses the identified compliance gap in a systematic and accountable manner. Specifically, it aligns with the principles of regulatory oversight that mandate firms to identify, assess, and remediate compliance failures. By investigating the root cause, the firm demonstrates a commitment to understanding the underlying issues rather than merely treating symptoms. Implementing corrective actions and reviewing policies ensures that the identified weakness is not repeated and that the firm's control environment is strengthened. This proactive and thorough response is crucial for maintaining regulatory compliance and demonstrating due diligence to regulatory bodies. An incorrect approach would be to dismiss the audit findings as minor or to implement superficial changes without understanding the underlying cause. Dismissing the findings as minor constitutes a failure to adhere to the firm's internal compliance framework and potentially breaches regulatory expectations for proactive risk management. This demonstrates a lack of professional diligence and could lead to more significant compliance issues down the line. Implementing superficial changes without a root cause analysis is ethically questionable, as it creates a false sense of compliance. This approach fails to address the systemic issues that led to the audit findings, thereby exposing the firm to continued regulatory risk and potentially violating principles of integrity and accountability expected by regulatory bodies. Another incorrect approach would be to immediately escalate the matter to external regulators without conducting an internal investigation. While transparency with regulators is important, bypassing internal investigation can be seen as an overreaction and may damage internal confidence and the ability to effectively manage the issue. It could also be perceived as a failure to take ownership of internal control processes. Professionals should adopt a decision-making framework that prioritizes understanding the problem, assessing the risks, and implementing proportionate and effective solutions. This involves consulting relevant internal policies, regulatory guidance, and potentially seeking advice from compliance or legal experts. The process should be documented at each stage to demonstrate a clear audit trail of the firm's response and commitment to compliance. Question 19. Investigation of the process by which Astra International's compliance department evaluates potential operational risks associated with the introduction of a new automated trading platform, considering the need for a robust and forward-looking assessment. Option A. The compliance department will prioritize identifying risks that could immediately impact revenue generation, deferring the assessment of less immediate but potentially significant risks. Option B. The compliance department will review historical incident reports from similar platforms in the industry and assess the likelihood and impact of those past issues recurring with the new platform. Option C. The compliance department will conduct a scenario analysis that considers potential system failures, cyber attacks, and human error, quantifying the potential financial and reputational impact of each scenario and developing specific control measures. Option D. The compliance department will rely on the technology vendor's risk assessment report for the platform, assuming it adequately covers all potential operational risks. The correct answer is B. The compliance department will review historical incident reports from similar platforms in the industry and assess the likelihood and impact of those past issues recurring with the new platform. Explanation: this scenario presents a professional challenge due to the inherent subjectivity in risk assessment and the potential for bias to influence judgment. Astra International, as a global financial institution, operates under stringent regulatory frameworks that mandate robust risk management practices. The challenge lies in ensuring that risk assessments are objective, comprehensive, and consistently applied across different business units and geographical regions, while also being adaptable to evolving market conditions and emerging threats. The need for a structured and evidence-based approach is paramount to avoid regulatory breaches and maintain client trust. The correct approach represents best professional practice because it emphasizes a systematic and documented process for identifying, analyzing, and evaluating risks. This aligns with regulatory expectations for a proactive and diligent approach to risk management. By focusing on the likelihood and impact of identified risks and then developing appropriate mitigation strategies, the firm demonstrates a commitment to safeguarding its assets, reputation, and clients' interests. This structured methodology ensures that decisions are informed and defensible, reducing the likelihood of unforeseen losses and regulatory sanctions. Adherence to established risk assessment frameworks, such as those promoted by regulatory bodies, is a cornerstone of responsible financial conduct. An incorrect approach that relies solely on historical data without considering forward-looking indicators would be professionally unacceptable. This fails to account for new or emerging risks that may not be reflected in past performance, leading to a potentially inadequate risk mitigation strategy. Such an approach could violate regulatory principles, requiring a forward-looking perspective on risk management. Another incorrect approach that prioritizes short-term profitability over identified risks would be ethically and regulatorily unsound. This demonstrates a disregard for the firm's fiduciary duties and a potential violation of regulations designed to protect against excessive risk-taking. Prioritizes immediate gains at the expense of long-term stability and client protection. A third incorrect approach that involves delegating risk assessment to individuals without adequate expertise or oversight would be a significant failure. This undermines the integrity of the risk assessment process and could lead to misidentification or underestimation of critical risks, potentially resulting in breaches of regulatory requirements for competent risk management. Professionals should employ a decision-making framework that begins with clearly defining the scope and objectives of the risk assessment. This should be followed by a comprehensive identification of potential risks, drawing on both historical data and forward-looking analysis, including market trends, geopolitical events, and technological advancements. Each identified risk should then be analyzed in terms of its likelihood and potential impact. Using a consistent and defined methodology, mitigation strategies should be developed and prioritized based on the risk appetite of the organization. Finally, the entire process must be documented, regularly reviewed, and updated to ensure its continued relevance and effectiveness, with clear lines of accountability established throughout. Question 20. What factors determine the most effective prioritization of identified risks within Astra International's operational framework, considering potential regulatory implications? Option A. The level of attention a particular risk has recently received from senior management and external stakeholders. Option B. The historical frequency with which similar risks have materialized in the past, irrespective of current market conditions. Option C. The potential impact of the risk on the firm's strategic objectives and financial stability, combined with the likelihood of its occurrence. Option D. The ease with which mitigation strategies can be implemented for each identified risk. The correct answer is C. The potential impact of the risk on the firm's strategic objectives and financial stability, combined with the likelihood of its occurrence. Explanation: This scenario presents a professional challenge because it requires a nuanced understanding of risk assessment beyond simple identification. The firm is not merely asked to list potential risks, but to prioritize them based on their potential impact and likelihood, considering the specific context of Astra International's operations and regulatory environment. This demands a judgment call that balances quantitative data with qualitative assessments, ensuring that resources are allocated effectively to mitigate the most significant threats. The correct approach represents best professional practice because it aligns with the principles of robust risk management frameworks, which are often mandated or strongly encouraged by regulatory bodies like those governing financial services in the UK, e.g., the Financial Conduct Authority (FCA). Specifically, a comprehensive risk assessment involves not only identifying potential risks, but also evaluating their likelihood and potential impact. This allows for a prioritized response, focusing on risks that pose the greatest threat to the firm's objectives, financial stability, and reputation. Such a systematic approach ensures compliance with regulatory expectations for sound governance and risk management, demonstrating due diligence and a proactive stance towards potential threats. An incorrect approach that focuses solely on the historical frequency of an event without considering its potential severity or the current operational context fails to adequately assess risk. This could lead to underestimating or overestimating the threat, resulting in misallocation of resources and potential noncompliance with regulatory requirements for a proportionate risk response. Another incorrect approach that prioritizes risks based on the ease of mitigation overlooks the fundamental principle of risk assessment, addressing the most significant threats first, regardless of implementation difficulty. This can lead to the firm being exposed to high-impact, low-probability events that could have catastrophic consequences. Finally, an approach that solely considers the visibility of a risk to senior management, rather than its objective impact, is ethically flawed and professionally unsound. It suggests a reactive or politically driven decision-making process, which is antithetical to effective risk management and can lead to regulatory sanctions for a lack of objective assessment. Professionals should employ a decision-making framework that begins with a clear understanding of the firm's strategic objectives and its operating environment. This involves identifying potential risks across all relevant categories, e.g., operational, financial, strategic, compliance. Subsequently, each identified risk should be assessed based on its likelihood of occurrence and its potential impact, both quantitative and qualitative. This assessment should be informed by internal data, industry best practices, and regulatory guidance. The results of this assessment should then be used to prioritize risks, allowing for the development of appropriate mitigation strategies, controls, and contingency plans. Regular review and updating of the risk assessment are crucial to ensure its continued relevance and effectiveness.